歡迎各位出席今日嘅與實施無紙證券市場制度相關的6項附屬法例小組委員會嘅會議。再次歡迎財富局、證監會同埋律政司嘅代表啦。議程第一呢，就係同政府當局去舉行會議，去繼續逐條審議啦。逐條審議之前呢，就大家可以留意啦。喺台面呢，有一份文件係證監會提供嘅，就根據對上一次3月21號開會討論嘅一啲跟進嘅一啲回應嘅。咁或者我哋開始逐條審議之前，睇下證監會對於呢份文件有冇啲咩，或者局方有冇啲咩需要同我哋報告下。唔該。
多謝主席，各位委員，大家好。請證監會同事去到就上一次嘅會議嘅個別跟進事項作出回應之前呢，我希望簡單講講我哋呢個法例嘅思路同埋我哋嘅目的。上一次我哋會嗰度都有講過啦。其實我哋喺根據2021年我哋嘅修訂條例嘅框架底下呢，無紙證券市場嘅制度嘅附屬法例嘅訂明係喺新制度下面嘅運作同埋監管一啲嘅細節。法例條文包括我哋上一次討論有關持有人登記冊嘅規定呢，旨在訂定一啲適用於唔同發行人同埋核准證券登記機構必須要遵守嘅一啲最基本嘅水平。有關呢啲嘅基本水平嘅訂定呢，其實係由證監會喺2023到2024年所進行咗一系列廣泛嘅市場諮詢之後呢，而定出嘅一啲嘅基線嘅要求。以喺優先保障咧嚟自世界各地股東，涵蓋可能有啲年紀比較長，或者將來有機會繼續持有實體證券嘅股東，以及咧唔同種類嘅機構嘅股東嘅權益嘅基礎上咧，平衡各方包括上市人啦、交易所、中介人、核准證券登記機構嘅操作需要，並且預留一定嘅彈性咧，以照顧將來一啲可能我哋會見到嘅情況。未能達到，大家會留意到啦，未能達到我哋喺法例上面嘅要求呢，我哋係會有一啲嘅刑事嘅責任同埋規管嘅行動。我哋唔希望呢喺一啲嘅特殊情況之下，有發行人被逼違法嘅情況，或者佢嘅股東容易就某些嘅事宜呢，容易引起爭拗，咁會對推行我哋上市人同埋股東普遍使用未來嘅無紙證券制度咧，帶嚟一啲嘅影響。喺訂定我哋喺條例入邊寫嘅最低水平嘅基礎上咧，我哋可以透過其他嘅行政措施，譬如證監會會制定嘅核准證券登記機構操作準則同埋相關嘅指引，同埋一啲嘅上市規則等等咧，通過呢啲行政措施咧，將一啲我哋頭先講過啦，我哋一啲嘅最低要求以上嘅一啲更加好、更加優化嗰個嘅情況嘅細則同埋準則咧，可以喺呢度擺落去嘅。事實上咧，隨住金融基建嘅完善化同埋現代化，電子化程序對於發行人同埋證券登記機構喺行政工作同埋企業管治上咧都有相當嘅好處。以股東通訊為例，我哋預期喺推行咗之後咧，大部分嘅發行人同埋佢嘅核准嘅登記機構咧，都會喺開戶或者用其他嘅溝通渠道嘅時候咧，攞到股東嘅電郵地址，用電子嘅方式作為呢個通訊聯繫。我哋相信咧，業界亦都係樂意推行促進無紙化嘅措施嘅。喺上一次會呢，議員提到好多嘅具體建議，我哋都覺得係一啲好嘅建議。譬如吳傑莊議員啊、陳紹雄議員、簡慧敏議員、江玉歡議員呢，就喺嗰個登記冊入邊嘅個人資料，譬如話我哋係咪地址身份證號碼或者一啲嘅電郵資料啊？嚴剛議員亦都有提過呢，就話喺同股東通訊嗰陣時，係咪可以用郵寄以外嘅其他方法呢？呢啲呢，我哋覺得都係對於促進市場進一步邁向電子化，或者喺投資者保障同埋喺提升市場效率方面呢，都有一啲嘅正面嘅作用。 但係咧，由於即係部分可能牽涉嘅影響咧，可能比較大。即係譬如我哋今朝有幾位議員，我哋都有睇呢個穩定幣嗰個條例，就住譬如一啲嘅條款，我哋講電郵地址，我哋都要有一啲好具體嘅 definition， 我哋要擺落去。所以呢啲咧，我哋覺得係要小心，即係要睇清楚喺嗰個如何放落去，或者係咪放落去，或者如何放落去咧，我哋都要小心去考慮嘅。就住目前嘅各項嘅具體附屬法例咧，佢哋反映咗證監會喺之前講過市場諮詢期間參與者嘅所凝聚到嘅共識。但係雖然如此咧，就住即係議員喺之前有提過嘅建議咧，我哋同埋證監會咧就住進一步點樣去優化各項附屬法例咧，持有呢個開放嘅態度。而家議員審議嘅附屬法例喺審議期過咗之後咧，同埋政府喺有關修訂到實施中間咧，仲有一段嘅時間嘅。喺第一次會議，我哋嘅投影片都講過，我哋希望就係成個無紙化嘅框架就會喺明年年初生效啦。咁我哋嗰個嘅生效公告咧，我哋就相應會希望喺今年年底嗰度就去提交立法會嘅。我哋屆時咧可以就議員嘅提出嘅意見咧，可以做進一步嘅報告，包括我哋喺審視相關嘅行政措施之後嘅結果。即便就算喺新制度實施咗之後咧，我哋都係記得議員就住唔同嘅措施點樣可以進一步嘅優化咧，我哋都會繼續去睇嘅。以期呢，就係就算法例制定咗，我哋嘅呢個無紙化生效咗之後咧，我哋見到有需要嘅時候，點樣喺落實咗個情況，我哋見到情況係點，同埋我哋累積咗一啲嘅操作經驗嘅時候咧，有需要咧，我哋亦都可以做一啲法律方面嘅優化嘅。主席，我簡單講講就住當中上一次幾條嘅提嘅內容咧，我哋證監會同事可以逐一條去同大家go through 啊。
係證監會有冇啲咩繼續即係逐條審議啦？去到啱啱局方嗰個內容有冇啲咩其他補充啊？證監會
主席，我想問下，就需唔需要將我哋上次議員啲問題咧，我哋個回應咧，我哋喺度講一講，定係我哋可以直接去逐條審議啊？
唔使好詳細去係啦，即係就係啱啱基於局方講嘅內容，有冇啲咩補充啫？如果冇都冇其他補充嚇。冇
特別啦，主席，唔該。
好，咁我諗即係再次強調，我諗議員帶嚟嘅一啲意見，佢哋背後都有一定嘅即係佢哋嘅唔同嘅界別所遇到嘅困難，同埋即係佢哋表達呢啲咁嘅意見咧，希望嗰個政府雖然未必喺嗰個法律條文嗰度，因為都理解到即係喺嗰個對於備受監管又好，喺嗰個即係成件事情嘅唔同嘅持份者嗰個影響都會較大。但係啱啱我諗局方講到嗰個內容咧，就係喺一啲行政嘅措施咧、指引啊等等咧，亦都可以即係執行到一啲具體嘅細節，因為即係個魔鬼喺細節度啦嚇。咁所以嚟緊我諗即係我哋都即係希望證監會同埋嗰個局方繼續去隨着即係議員所提出呢啲嘅意見去推行。好啦，咁而家去到進一步逐條審議嘅，咁我哋上次咧就討論到證券及期貨無紙證券市場規則第3部嘅第12條，咁而家去到呢度咧，可以先證監會做一個介紹，從嗰度開始。係簡慧敏議員。
主席，唔好意思，我想就住即係頭先講嗰度咧，我哋理解嘅嚇，即係多謝副秘書長同埋即係證監會代表有提到即係嗰個我哋嘅關注同埋即係嗰個將來要持續檢視嗰個即係做法啦。咁咧就可能擺喺個規則個靈活性冇喺個即係核准證券登記機構嘅守則咁有靈活性同埋可操作性啦。咁不過你趁呢個機會，可唔可以同我哋同埋同公眾都解釋下咧？你喺個規則同埋嗰個守則嗰個意義啊，即係或者嗰個佢個地位上邊嚇，如果係個守則係咪主要即係點樣咧？係規管嗰個守則嘅對象，佢如果違反個後果係會點樣咧？嚇，唔該，主席。
係證監會。
簡議員啊，多謝你嘅提問。我嗰個守則咧，其實都係我哋證監會一向咧監管啲市場人士嘅一個做法嚟嘅，即係話我哋有個法例嘅要求啦，就係某啲市場嘅人士需要受證監會規管啦。咁喺呢個情況就係啲核准證券登記公司啦。咁但係喺法例度咧，我哋會有一個框架俾我哋去監管嗰啲機構，但係我哋通常都會有一啲守則咧列明咧，我哋唔同嘅關注嘅地方咧，我哋嗰個期望係乜嘢？咁如果係嗰啲同埋啲要求啊，咁如果啲核准證券登記機構咧，將來就住啲守則某啲條款，如果佢達唔到我哋要求咧，咁就其實係一個我哋會關注睇下佢係咪對我哋監管佢咧，我哋係咪需要再有一啲調整？咁即係簡單講咧，去到最嚴重咧，如果守則有一啲條款佢達唔到我哋要求咧，我哋可能會即係再審視下佢係咪合適作為我哋一個核准證券登記機構，或者我哋去到一啲例子，我哋可能施加一啲其他嘅條件，我哋先至可以繼續俾佢繼續運作咁。
係，即係話理解為可以話對佢發牌啦，或者持續俾佢去經營嘅一種嘅監管嘅手段嚟嘅嚇，喺個守則度就係。咁違反嘅時候咧，就對你嚟講亦都多啲靈活性係咪啦？即係你可以喺紀律上邊去處理佢，就並唔係規則上面咧，就係可能係罰款啊，或者係吊銷個牌照咁樣。咁你喺個 code 喺個守則就更多唔同嘅可以即係規管佢嘅，或者係紀律佢嘅做法係咪？
係啦，冇錯冇錯。
好，唔該。
好，逐條審議之前，都講一講，因為今日個會議安排嘅時間2點半到6點半，相對比較長，所以我哋開到大概一半嘅時間，我哋會有一個簡短嘅即係5分鐘嘅休息，咁啊先預告先。咁而家我哋可以交翻時間交翻俾證監會係逐條審議，第3部第12條嗰度，唔該。
Thank you very much, Mr. Chairman. So we go to Clause 12 of the USM rules. So Clause 12 deals with transfers by way of an instrument of transfer. Subclause 1 clarifies that the issuer has the prerogative to refuse the use of instruments of transfer to effect transfers that are in uncertificated form. Subclause 2 clarifies the particulars that the instrument of transfer must include. And Subclause 3 preserves the issuer's right to refuse to register a transfer on other grounds.
我哋停一停，陳仲尼議員。
多謝主席。主席啊，我就關心咧12條括弧3嗰度咧，頭先即係政府嘅同事都讀咗啦，就係話咧括弧1咧，即係佢唔係淨係局限於咧括弧1裏邊所講嗰啲情況下，嗰個發行人咧可以拒絕轉讓啦。咁我自己就擔心，即係其實會唔會寫得太闊啦？又或者可唔可以請局方咧解釋下，你哋擺呢個括弧3落去嗰陣時候咧，係覺得有啲咩嘅情況或者理由之下咧，即係佢係可以拒絕呢個轉讓？
證監會。
Yeah, thank you for that question. So generally, an issuer would have ability to refuse a transfer under, say, for example, their terms of issue or their articles or general law even. The idea of this legislation is not to affect any of that. So one example would be, for example, if the parties have placed an instrument of transfer before the company, but the details are inaccurate. For example, they are purporting to transfer 1,000 shares when they only have 800 shares. So the issuer should be entitled to reject that kind of a transfer, instrument of transfer. So the idea is that this legislation should not affect any rights that the issuer has currently in terms of how it deals with instruments of transfers or transfer requests.
主席，不過我頭先聽到同事佢答咧，嗰啲咪就應該係括弧2B 啊嗰啲講明咗咯。即係佢譬如話佢嗰啲股數唔啱啊嗰樣嘢，即係佢咪就係話任何關於轉讓唔啱嘅嘢喺2嗰度已經包咗。即係其實我冇問題嘅，但係我覺得第3咧係寫得好闊，因為又冇講明乜嘢 grounds， 又冇講明乜嘢嘅理由。咁我就所以就想即係了解下，即係其實你哋係諗到啲乜嘢嘅情景咧？
係啦，除咗啱啱嗰個即係你證監會提出相對比較合理，仲有冇啲咩避免太闊？
Yeah, another example would be if the certificate, for example, is forged. That would be another grounds for refusal.
係簡慧敏議員。
我都想解一解嗰個12(1)B 啦。 如果嗰個單位即係個標的單位係屬無紙形式嘅話，呢一條係講發行人可以拒絕佢個轉讓。咁我哋而家就做緊一個無紙形式嘅證券，我哋點樣去解讀啊？即係呢一條係咪你跟住後邊會有講到，如果係用無紙形式嘅股票嘅話呢，就係點樣去做個轉讓嗰個嘅登記呢？
Perhaps I can explain the approach we have taken in the entire part first in that case. So the idea is not to mandate when the issuer can use an instrument of transfer and when the issuer can use a specified request. And the reason for that is because we need to allow flexibility for the issuer to deal with unique and varied circumstances. The other concern is that we don't want the investor to demand how they can effect transfers. So for example, we don't want a situation where the shareholder actually holds the shares in uncertificated form, but insists on using an instrument of transfer. So the way we have done the legislation is basically to give the issuer the prerogative to decide that when they can refuse an instrument of transfer. And the general idea is that if the securities are in uncertificated form, it is the prerogative of the issuer to say, no, I'm not going to accept an instrument of transfer. And then likewise, if the securities are in certificated form, then it is the prerogative of the issuer to say, I'm not going to accept a specified request. And if they are in uncertificated form, it's the prerogative of the issuer to say, I'm not going to accept an instrument of transfer. So the basis of this is that the issuer and its share registrar will necessarily always endeavor to use the most effective means. They will not be able to use a specified request as a means to effect transfers of certificated securities. Likewise, if the securities are in uncertificated form, they would not be inclined to constantly receive instruments of transfer. So the idea here is to build in a degree of flexibility so that the issuer can deal with unique circumstances without the investor insisting on the method of use.
主席，我諗就係由於我哋唔係好知道咩叫做 specified request 因為我哋可能未去到嗰條指明請求啊。我而家咁樣初步聽呢個理解就係話，我哋如果嗰個本來即係你局方即係證監會解釋 investors 咧，我相信係你解讀為即係買賣雙方啦。如果嗰個本身個股票咧係一個無紙形式嘅，咁嗰個文書即係呢度就講個轉讓文書嘛，咁亦都令到嗰個投資者兩方咧就係唔一定應該話令到個賣方就唔可以一定要用紙。即係 instrument of transfer 用一個轉讓文書嘅方式先至嚟到去做呢一個轉讓係咪啊？你想解釋嘅就係因為等於你後邊講 specified request 嘅時候咧，係咪專門愛嚟處理嗰個無紙形式嘅轉讓個登記咧？即係你既然係無紙啦嘛，咁你就唔想佢用翻一張 instrument of transfer 有紙嘅嚟到去轉讓嚇。我諗要解釋翻，你擺翻落個 scenario 度好啲個情景啊，唔該。
我諗我就試下解一次啦，簡議員嗱，即係第12咧1咧，其實就係話咧，發行人可以拒絕一啲轉讓，嗰個轉讓咧係基於一啲紙張嘅轉讓文書啊嘛，咁所以嗰度咧我諗係去即係避免一啲誤會啦，所以12(1)B 咧就講明，就算嗰個標的單位係無紙嘅。即係話有一個投資者，如果佢揸住嗰個股票係無紙形式，如果佢想用一個紙張嘅轉讓文書咧，個發行人都可以拒絕嘅。
或者我哋睇埋後邊即係指明要求啊。
好江玉歡議員。
主席，我想就有關頭先陳仲尼議員問嗰個問題咧，我認為咧喺第3條呢度咧，可唔可以或者請證監嗰度都講清楚嗱，因為第3咧確實咧係任何情況底下都可以拒絕嘅。 雖然咧我知道你哋好好寫咗附注，咁你可唔可以俾翻一啲 comfort 我哋大眾市民，就係話都係基於一啲合理合法嘅情況底下，你哋先會去到拒絕嗰個登記咧嚇？呢一度雖然你文字上冇寫，咁但係喺呢個法案委員會裏邊，你可唔可以都有一個記錄話俾我哋聽，係會基於呢啲咁嘅理由先會去到拒絕咧嚇？唔該。
證監會。
Thank you for that question. So yes, indeed, the issuer would be expected to act reasonably. Yeah.
我諗最主要個關注點就係現時啱好明顯提咗出嚟一啲比較合理嘅，好似啱啱所講用咗一個股數，佢都唔存在有足夠嘅股數，咁你冇可能要求一啲嗰個持股人唔擁有嘅一啲股份去作出一啲行動啦。咁不過同時間，我諗其他委員大家關注嘅地方就係會唔會即係太闊？咁啱都聽到啦，即係都要有一個合理嘅一個範圍之內啦嚇。即係雖然喺個文字上就睇唔到有額外太多嘢箍住呢樣嘢。OK， 咁或者我哋冇其他問題就繼續可以證監會逐條審議可以繼續嚇。
Yeah, thank you, Mr. Chairman. So we move on to Clause 13. So Clause 13 deals with transfers by way of a specified request. Subclause 1 clarifies that the issuer has the prerogative to refuse the use of a specified request to effect transfers under certain circumstances, and these include where the securities are in certificated form or are in the process of delisting. Subclause 2 clarifies what constitutes a specified request. So basically, it's 2 authenticated messages, one attributable to the transferor and the other to the transferee. Subclause 2 also clarifies the particulars that the specified request must include. Subclause 3 allows for a specified request to consist of a written instruction instead of an authenticated message in certain circumstances. And Subclause 4 preserves the issuer's right to refuse to register a transfer on other grounds.
我哋呢度停一停，譚國強議員。
主席，我是問一下這個13條這個第一的 D， 就是基於指明請求而登記轉讓並非合理的，切實可行。因為前面 A、B、C 都是比較明確的，但是 D 的話呢，這個並非合理的，並不是那麼的明確的。這裡面有沒有什麼準則？或者舉個例子說明一下，謝謝。
係證監會。
Yeah, thank you very much for that question. In putting that particular paragraph in, our main concern was to tackle situations of takeover offers. So in a takeover situation, particularly where the takeover is a hostile takeover, the share registrar acting for the offeror will not be the same share registrar as the target company's share registrar. And so that share registrar will not be in a position to receive electronic instructions. And so it may be necessary for paper instructions to be provided. So that paragraph is designed for that scenario. We did not specifically cast that to refer to the takeover scenario in case there were other situations with similar practical limitations that we cannot currently think of, so that it could cater for those situations as well.
OK， 下一位我自己都有個問題，就係喺第13點嘅 C 個部分啦。其實呢度都有提及到，即係如果一啲除牌嘅程序同埋喺除咗呢度，仲有啲其他條文都會有提及到除牌嘅。咁當然我哋嗰個預算案入邊都有提及過未來即係都會去檢討一下，如果除牌嘅機制咁再設立一個場外一個交易嘅一個版。咁當然我知道而家呢啲嘢係一啲可能長線可能發生可能唔發生嘅事情，咁但係對於到陣時係咪都再要跟進翻改翻條法例咧？因為而家寫嘅方式就都足夠一個即係包含到未來如果有啲咩改變咧，即係都唔會受到影響。
主席，你嗰個問題我估咧，主要都要睇翻咧將來如果係設立一個已經除咗牌嘅平台嘅買賣嘅平台嘅時候咧，其實個細節係點啊？ 因為而家都坦白講未有一個叫初步諗法係點啦。我諗要睇埋個細節，我哋先至可以決定得到。咁我諗呢度暫時我哋如果將來真係大家有個共識，設立一個已經除牌嘅公司都可以做買賣嘅平台，我哋會睇埋呢度無紙化嗰啲法例需唔需要有一啲相應嘅修訂
？OK， 好，唔該。下一位簡惠敏議員。
主席嗱，我哋而家處理緊13條啦，咁我不如請局方解釋一下，如果喺無紙證券同埋咧12條下無紙，13咧就係講有紙證券嘅，咁嗰種我哋即係嗰個轉讓嘅登記會係點樣做咧？然後即係俾嗰個發行人個權去拒絕嘅時候，係即係同你前面係應該點做係有啲關係嘅嚇，或者可以解一解唔該。
係，證監會。
So the idea is that where the shareholder is holding certificated securities, even if the transferee is going to hold in uncertificated form, the transfer will be effected by way of an instrument of transfer. This process is simply one that has been agreed among the share registrars and ourselves and the exchange because it's pragmatically the most sensible way forward. Because in any case, in that situation, you will need to attach the paper title document. So it makes sense to just allow that whole process to be a paper one. For all other situations where the securities are already in uncertificated form, the intention is that it would be electronic. As you will see, we have allowed for a scenario where a paper instruction may be received. So that is in 13.3. And the reason for that is twofold. One is to allow for some flexibility to deal with investors who may not be as tech savvy and who may need some assistance, especially elderly investors. Secondly, it's also to deal with the situation of joint holders, because as we understand, not all share registrars may be able to provide a facility, an electronic facility for joint holders from the get-go. So in order to allow for this degree of flexibility, 13.3 allows for instructions to be by way of paper to some extent. But the actual transfer, so what happens is that the paper instruction goes to the share registrar, and then the share registrar will then continue the entire process electronically. I don't know if that answers your question.
係主席，我諗聽嚟咧就即係話，對於嗰個registrar 即係個登記處啦、個證監會啦、exchange 啦，即係交易所咧，都同意咗相關嘅呢個做法啦，就係話要視乎嗰個轉讓個標的嗰個證券係乜嘢啦。如果個標的證券咧現時係有紙嘅，係一個仲係有紙型嘅話咧，就係個 sell side 佢就係揸住一張有紙嘅證券啦。咁就算嗰個買方嚇佢想用一種無紙化形式嚟到去持有咧，咁都會係用紙本嘅形式去轉讓嘅，就視乎嗰個賣嗰個 subject 係乜嘢啦，係有紙定無紙嚇。咁如果翻返去睇第12條咧，就係話如果賣嘅時候咧已經係一個無紙嘅證券嘅話咧，個發行人咧就有權去拒絕你用一個轉讓文書去轉讓啦，咁樣嚇。咁而喺有紙嗰種情況去做嗰個經認證信息嗰度咧，呢度我諗都要解解個操作啊。點解會即係話你話對於一啲老友記嚇，即係可能長者嚟講咧，佢會想保留翻3B 嗰種嘅選項，係咪因為你驚佢未必有一種手機嘅工具俾佢去發一啲認證嘅信息啦？如果冇呢個問題嘅時候，咁將來嗰個轉讓係點樣樣？你嗰個 authenticator message 經認證信息係點樣樣運作啊？唔該。
Yeah, so it is intended, thank you for the question, it is intended for people who really can't deal with electronic transfers. It's really there just as an additional flexibility. I know that a lot of elderly investors are actually quite tech savvy. It's only really for a small population that may not be. And it's really there to allow some flexibility for the share registrar to deal with that situation. The concept there is, or the expectation there is that the investor may come to the the share registrar's counter and provide some sort of written instruction, and then the share registrar, based on that written instruction, might input the relevant information into their system, and so in that sense you still have an electronic transfer. So it's really just a way of finding a right balance to deal with all these different considerations.
好，多謝。
好，下一位何敬康副主席。
Yes, I got two questions. In the event that a written instruction is required under any circumstances, is there any process in place to expedite the authentication process to make sure that it's swift, it's done swiftly? Is there a process to expedite that so that no further delay? And also that it's mentioned there that it's as long as it's reasonable and also practicable. Can you give me like an example where it's not reasonable and not practical?
Sure, thank you for the question. So first, your question was about expediting the transfers where there's a written instruction.
Yes.
So I think what we are anticipating is a situation where the person giving the written instruction is actually approaching the share registrar physically at their counter. And so all the relevant information would be received and input into the system. In terms of the time needed or the time within which these transfers need to be effected, the intention is that transfers by specified request must be done as soon as possible. And we have in the ASR code indicated that certain timelines, and in the case of transfers which involve deposits into CCAS, for example, the timeline we're looking at is within the T+2 settlement cycle.
Okay.
So because there are different scenarios, but we have elaborated on this in the ASR code to make sure, number one, that it's done on an as soon as practicable basis. So it's not that they have 2 days to sort of sit on it, but they do it as soon as practicable, and 2 days or whatever the period is the absolute maximum. And it's much shorter than the current 10 days.
Okay.
第二部分個問題有冇啲咩
Yeah, what kind of
唔合理嘅
situation that would be
Right.
deemed unreasonable and impractical?
I suppose if so yeah, you're right, this is an AND connector. So like I said, the tech-savvy carve-out and the carve-out for joint holders, that's the main reason for that paragraph B. So if in fact the share registrar has a facility for effecting transfers by authenticated instructions for joint holders, then we do not expect them to be relying on this. The reason we put that in is because we understand that it is an expensive system to build in for the share registrars, and they have quite a lot to do to implement USM from day one. So we understand the need to prioritize. But as and when they get their systems to be able to cater for joint holders, we do not expect them to be giving this option to such holders. In the case of tech-savvy holders, I guess there wouldn't really be such scenarios. I mean,
How do you determine someone who is tech-savvy or not tech-savvy?
I think I would expect the share registrar to take a common sense approach and look at all the circumstances.
Okay.
Yeah, and I should add that it's in the share registrar's interest and also the issuer's interest not to encourage this kind of instruction.
Fair enough.
Yeah.
OK， 可以繼續第14點可以繼續審議啊。講到。
Thank you, Chairman. So we go on to Clause 14. Clause 14 deals with transfers from a minority shareholder to an offeror pursuant to a buyout under the company's ordinance. The CO provisions refer to the use of an instrument of transfer when effecting buyouts, and the relevant provision has actually been amended under the 2021 Amendment Ordinance to allow for these transfers to be effected by way of an instrument of transfer or a specified request. So against that background, Subclause 1 clarifies that Clause 14 applies in relation to a minority buyout under the CO. Subclause 2 clarifies the requirements where an instrument of transfer is used to effect the transfers from a minority shareholder to the offeror. So it specifies who may execute the instrument and the particulars to be included in the instrument. And subclause 3 clarifies the requirements where a specified request is used to effect transfers from a minority shareholder to the offeror. I think just one point to add in light of members' earlier questions. The option is given to the offeror as to whether to use an instrument of transfer or a specified request, because depending on the specific circumstances of the case, they may not be able to use one or the other. So the idea is to give the offeror the flexibility.
江玉歡議員。
主席，我想問翻個關於呢一部分一個即係少少嘅問題，就係其實頭先喺嗰兩個 section， 即係12、13嗰度咧，都有講到個 issuer 咧係有權可以 refuse to register 嘅。我想請問多一句啫，就係話如果喺嗰種咁特殊嘅情況底下，個 issuer 有冇責任係向 SFC 係通報嘅？譬如喺 listing rules 裏邊。
So when we come to the ASR rules, you will see that we have notification requirements. And one of the notification requirements is a half-yearly reporting. And one of the items that we would require them to report in that is whether they have refused any transfers.
嚴剛議員。
主席，唔好意思咧，我可唔可以翻嗰個第13條嘅？13條嘅嗰個 C 咧，嗰個第一嘅括弧 C 嘅話咧，該等證券咧正處於嗰個除牌嘅程序嘅。咁咧除咗除牌咧，仲有停牌嘅。咁咧停牌咧係咩考慮？停牌係咪都係唔俾嘅？咁咧可唔可以解釋一下？
係請監委。
Thank you for the question. So if I've understood it correctly, it's talking about where the trading is suspended. So when trading is suspended, there would not be any transfers anyway. So I'm not sure. Yeah, I suppose you can still deposit the shares into CCAS. I beg your pardon, yes, you're right. You can deposit the shares into CCAS. This would not apply in that scenario. We're not looking at that scenario where trading is suspended. We're looking at the scenario where the securities are in the process of delisting. Maybe just to expand why that requirement is in there, it's really because if the securities are already in the process of delisting, and for whatever reason the investor wants to use a certificate, an instrument of title, an instrument of transfer, there's no real need to persist with the use of a specified request. That's the reason for putting paragraph C in.
所以主席，我係咪建議咧係加上嗰個咁啊停牌兩個字咧，仲係比韓國比較全面一啲㗎嘛？啱講嘅係停牌咧，時間咧當然你唔可以俾轉讓啦。但係咧，你如果加上係咪更加全面啲咧？停牌、除牌時候咧都唔俾啊。
或者梁生有冇啲咩補充啊？係咪啊？
我諗我解釋多次啦，即係13C 咧，我哋中文用嗰個字咧係叫除牌，除牌即係 delisting， 即係嗰間上市公司唔再有資格喺交易所嗰個平台度掛牌做買賣。咁呢個情況咧就唔可以再做噶啦。咁你提嗰個例子咧，停牌即係可能短時間有好啲原因，佢暫時唔可以做買賣。咁呢個唔包落呢個在內。咁所以嗰個停牌同除牌係兩件事嚟嘅。咁所以呢度已經清楚，因為呢度淨係針對除牌，唔係停牌嚇。
一個適用程度，我諗即係未必係喺呢一個條文就即係你除牌就會有個影響，但係喺個停牌就因為基於即係可能隔半日啊，或者幾個鐘頭，或者隔幾日佢就會復牌啦，咁就佢就未必影響到。
所以
我諗呢個係
C 嗰度停牌係唔受影響嘅嚇，即係 C 嗰個淨係包括除牌嗰啲。
所以唔包喺入邊停牌係嘛
？OK， 繼續嚇，證監會。
So then we can. Sorry, thank you, Mr. Chairman. So we can move then on to part 4, I think, which is on authenticated messages. So part 4 deals with the use and effect of authenticated messages. Clause 15 expands on what constitutes an authenticated message. So subclause 1 clarifies that the message must first relate to prescribed securities. Secondly, it must be sent using messaging facilities of the relevant recognized clearinghouse or ASR, and must be sent in accordance with the operating rules of those facilities. And thirdly, it must be one that is between either an issuer and a registered holder or transferee, or between an offeror and a registered holder. Subclause 2 expands on the meanings of various terms used in Subclause 1. All the definitions are largely for drafting purposes, so they seek to identify the particular issuer or offeror or operating rules or registered holder in the context of Subclause 1. And also in the case of the definition of operating rules, the definition seeks to clarify that it refers to rules or procedures that govern communication of messages using the facilities concerned.
江玉歡議員。
主席，我想請問一下關於 operating rules 嗰度咧，我唔熟悉嘅操作咧，我想請問一下點解 recognized clearing house 同 approved securities registrar 嗰個寫法會唔同，後者會 elaborated 咁多嘅，想請問點解咧嚇？
證監會啊。
Yeah, thank you for that question. So the reason is because the term rules in the context of a recognized clearinghouse is already defined in Schedule 1 of the SFO, whereas not for ASRs.
好，我呢個環節我都有少少問題想問，因為我諗之前如果冇記錯，好似簡議員曾經都提過，有陣時有啲定義咧喺條文入邊，有冇啲咩特別考慮，即係唔係放喺前邊？因為上一次開會咧，我哋都有部分嗰啲條文咧，就係淨係放咗喺其中一部分嘅條文，或者呢個可以係啦，律政司代表要開咪。
擺翻喺個規例通常第2條啦，就會擺係啦，就係咁樣去分。咁我諗即係呢度第15條嗰啲定義咧，全部佢咧其實第15條嗰啲定義咧係適用於第4部嘅，唔係 sorry 係第15條嘅，咁所以佢就會喺翻15條嗰度咯，係。
即係佢就換句話嚟講，唔適用於喺其他地方。但係上次我哋討論嗰個情況咧，就係適用於成個條文嘅，咁所以就可以搬翻到去上邊。但係呢個就唔係，係咪咁意思啊？
或者如果主席係講緊上次開會講嗰個電子文本同埋hard copy form 嗰兩個定義咧，咁我哋其實我哋翻去考慮過之後咧，其實係我哋喺嗰個回覆度就講咗係會留翻喺第8條嘅。咁個原因就係因為咧嗰兩個定義咧係真係適用於第8條嘅啫。咁個原因就係第8條咧係參照公司條例底下嘅相關嘅規則。咁公司條例嗰個規則入面咧有呢兩個定義，咁所以我哋為咗要兩個條文嘅運作係一致咧，第8條就要加翻嗰個定義。咁但係就住第6條都有用到 electronic form 同埋 hard copy form 呢兩個字。咁但係咧，因為第6條係USM， 即係我哋無紙證券呢個獨有嘅條文嚟嘅，咁就所以就唔需要同公司條例嗰啲有個一致性。咁我哋考慮到其實hard copy form 同 electronic form 呢兩個字本身佢嗰個通常嘅涵義咧已經可以係適用，咁所以咧就冇需要去將第8條嗰個特登引埋落去第6條嗰度咯。
好，唔該。江玉歡議員。
主席，好多謝你記得呢個問題嚇。我想請問一下啦，咁就因為主席呢個問題啦，其實喺第15條嗰度咧，喺個 definition 嗰度 registered holder 特別同埋 issuer 咧，其實喺 section 2都已經 define 過㗎啦。咁嗱，你呢一度咧就係話 in this rule 嚇，就咁樣解，就要用特別呢一種解釋嘅。咁嗱，我又想請問一下啦，咁去到第18 section 18咁先算啦，都有出現 register holder 嘅喎。咁我究竟係我想請問一下，咁我應該係如果係去到第 section 18啊頂頭 B 嗰度嘅一 boy 又出現咗 register holder， 咁究竟我應該用 section 2個 definition 啦，定係用 section 15個 definition 咧？請問呢個第一個問題。第二個問題就係話， 其實係咪真係要咁仔細？我就睇 register holder 同埋 issuer， 其實真係一定要 redefine 過咩？我想請問一下，係咪真係要咁樣做咧？想問下 DOJ 嘅同事。
係律政司嘅代表。
多謝主席同埋多謝江議員嘅提問啦。咁呢兩個定義咧喺第15條嗰度有再定義個原因，就係因為咧我哋第4部咧係講緊關於 authenticated message 即係經認證信息嘅條文。咁所以咧就我哋會就住經認證信息乜嘢為之係登記持有人同埋受養人啦，同埋係發行人呢啲咧就會再有個定義咁樣嘅。
主席，我想 make 一個 note 啫，即係嗱，我認為除非真係好有必要啫。舉個例子喺一個法例嗰度，咁唔通某一個人就出封信，咁你要喺嗰個 section 嗰度講嗱，如果我講呢，凡指出封信嘅時候就係出信嗰個人咯，咁即係我有時覺得係未必要，不過呢個我一個 note 啫，我唔係要佢哋改，即係我自己咁嘅睇法。唔該，主席。
係 OK， 唔該，施生。
留意到。
OK，簡慧敏議員。
主席，我都多謝你記得起上次第8條同埋第6條啦嚇。其實即係局方嘅回應對於第8條、第6條點解做佢而家嗰個做法咧？我自己個人就覺得即係都有即係完善嘅空間嘅嚇。不過即係本身唔係一個即係好主要嘅啦嚇。即係因為你第8條其實解嚟解去個解釋都係話跟翻公司條例嘅相關條文，佢因為第8條所以又搬翻過嚟，就要定義翻。乜嘢叫做電子形式，咩叫印本形式咁樣？咁但喺第6條咧，就好似你頭先指出咁啦。第6條其實都有出現呢個字嘅，喺嗰度就唔定義，就用佢本身字義嗰個嚇，即係原來佢個 ordinary meaning 佢個。咁但係 hard copy form 嚟計啦嚇，以 hard copy form 咧，其實定義咗嘅話咧，係講得比較闊啲嘅嚇，即係包括紙本或者係其他嘅形式咁樣。咁係唔係自己用佢個即係第6條唔使定義佢咧，就係清晰咧咁樣？即係我自己覺得個解釋係有少牽強嘅，即係為咗要解釋你點解第8條要照抄落嚟，又唔喺第6條定義啦咁樣嚇。睇下局方有咩回應。
係邊位回答？係施生。
要咪。
施生係俾施生個咪。
要咪係。咁多謝議員嘅提問啦。咁其實我諗呢度真係係按需要，因為我哋寫法例嘅時候咧係真係睇嗰個需要。咁第8條嗰度係有個確切嘅需要，係即係確保呢度即係 USM rules 同埋公司條例規則嗰個運作一致咧，所以我哋先至會擺翻嗰個定義喺度。其實本身如果冇第8條嘅話咧，我哋覺得係電子形式同埋印本形式呢兩個字，特別係咧。第6條裡面咧，其實佢有再講多啲嘅啫。佢有講其實係電子形式就係去傳送去該人指明嘅電子地址啦。印本形式咧就係將有關通知郵寄去嗰個人最後為人所知嘅地址啦。咁所以其實第6條本身係會詳盡啲，即係佢自己個條文係會詳盡啲去解説嗰個實際嘅嗰個傳送嘅模式嘅。咁所以本身其實我哋覺得第6條係真係唔需要另外特別有定義係。
但係主席，我諗咧，你個重點其實係講咩叫印本形式啊？唔係講送嗰個形式。印本形式咧，你第8條定義咧就係講紙張形式或能夠供閱讀的相類形式咯，係就住印本形式而定義嘅，唔係就咧嗰種即係寄送或者係派送嗰種方式嚟到去定義嘅。其實另外一個做法，如果你想將公司條例去保持一致咧，你亦都可以話在本條中引用到呢啲字嘅時候咧，就依據公司條例嘅第11條，即係引述翻嗰個嚟到去講係乜嘢定義，係咪一樣可以咧？即係因為你咁樣做法咧，就會引起我哋可能及後都會有呢啲嘅疑問嘅。即係正如頭先江議員嗰個係另一個例子，點解你喺第15條定義咗，但係喺後嚟又有用呢個字，咁係咪當用翻 register holder 嘅時候，我就睇第2條咧，就淨係第15條先適用你第15條嗰個具體定義咧，真係有少少混亂啊！唔該。
係啦，或者我諗可以證監會去睇下有冇任何優化空間啦。即係當然，即係呢個原則性未必係影響到極之重大嘅一個情況。不過即係都對於嗰個成個係啦個解讀會可能會順啲，睇下有冇任何優化空間啦。 咁好，冇其他問題，我哋繼續啦嚇。
Thank you, Mr. Chairman. So we move on to Clause 16. So Clause 16 deals with the attribution of authenticated messages. Subclause 1 provides that an authenticated message is attributable to a person if it is expressed or otherwise identifiable as being sent by or on behalf of that person. And Subclause 2 clarifies that an authenticated message may be attributable to more than one person, and where it is expressed or identified as being sent by one person on behalf of another, it is attributable to both of these persons. Moving then to Clause 17. Clause 17 clarifies who are to be regarded as addressees of authenticated messages. Subclause 1 provides that the addressee of an authenticated message is the person to whom the message is expressed to be addressed, or otherwise identifiable as being addressed. And Subclause 2 clarifies that the addressee, there can be more than one addressee, and where it is expressed as being addressed to one person on behalf of another, then both persons are to be regarded as addressees. Clauses 18 to 21, they deal with the effect of authenticated messages. So starting first with Clause 18, this delineates the extent to which these provisions apply. That means the provisions 18 to 21. Subclause 1 clarifies that the provisions apply only in respect of authenticated messages that relate to rights, benefits, or privileges attaching to prescribed securities, and the particulars of a registered holder of the prescribed securities. Subclause 2 clarifies that the provisions, that is clauses 19 to 21, apply without prejudice to the liability of any person for causing or permitting the message to contain inaccuracies or to be sent without authority. Clause 19 deals with authenticated messages sent by a principal. Subclause 1 clarifies the extent to which the provision applies. So it applies where the message is sent by a person on their own behalf, i.e. as principal. And Subclause 2 provides that the person sending as principal cannot deny that the information in the message is correct or that the person sent the message. Clause 20 deals with authenticated messages sent by an agent. Subclause 1 clarifies the extent to which this provision applies. So it applies where the message is sent by a person on behalf of another. Subclause 2 provides that the principal cannot deny that the message was sent with their authority or that the information in the message is correct. Subclause 3 provides that the agent cannot deny that they had authority to send the message or that they sent the message.
江玉歡議員。
主席，我有兩個問題。第一就喺19嗰度咧，19想請問19個1嗰度，咁想請問會唔會可以 disprove by 呢個 fraud 或者係 mistake 嘅咧？另外就係喺20嘅2所謂有呢個2A 所謂有呢個 principal's authority 呢度，請問可唔可以 clarify 一下，係咪包 actual 同埋 implied authority 嘅？唔該。
證監會。
Yes, thank you for those questions. So I think it's important to bear in mind that authenticated messages are sent through an electronic system and through a USI facility. So the way it works is that the person entering the instruction would have a username and password. So similar to what you do with online banking, for example. And the person sending the message, if it is an agent, would have the authority to send through that USI facility. So you asked whether the message can be, whether the authority, I think, can be disproved if there is no authority or if it's by mistake. Yeah. The way it would work is that so long as the USI facility is used and used in accordance with the terms of the operating rules, it will be binding on the person sending the message or the person to whom the message is attributable. And if there is any dispute as between, say, for example, a principal and an agent, then that would be something that they need to sort out. Because the concern is that the addressee should not be affected. The addressee should be entitled to rely on a message that has been sent in accordance with the operating rules and sent in accordance with the rules of requirements of these provisions. So if there is some fraud between the principal and agent, for example, then that is a matter that they need to sort out.
主席，我想問多一句，即係話我嘅諗法，即係喺19同埋20，19同20係兩樣嘢嚟嘅。即係話，如果喺19無論有欺騙嘅情況 fraud 或者有 mistake， 只要其實嗰個 authenticated message 係 being sent 嘅時候咧，其實就已經冇得翻轉頭㗎啦。OK， 即係話等嗰個victim 同佢自己報警或者佢去拉嗰啲人咯，係咪？而20咧就係喺 principal 同埋 agent 嘅情況，即係話無論嗰個 agent 如果佢冇實質或者冇 implied 嘅 authority， 如果佢做咗個 authenticated message 一出嘅話咧，其實呢個就會變咗係 a matter between 嗰個 principal and the agent 啦。啱唔啱咧
？Yes, that's correct.
Okay.
I think it's worth. Oh. Okay.
係有冇回答咗個問題？冇其他跟進。OK， 好，或者證監會可以繼續。
So we move then to clause 21. Clause 21 clarifies the right of an addressee to rely on an authenticated message. Subclause 1 provides that an addressee may accept the following. First, that the information contained in the message was correct. Secondly, where the message is attributable to a person as principal, that the person sent the message. And where the message is attributable to a principal and an agent, that the message was sent by the agent with the principal's authority. Subclause 2 clarifies that an addressee may not accept the matters set out in subclause 1 if they had actual notice of certain things. First is that any information in the message was incorrect. Secondly, the person expressed or identified in the message as having sent it did not in fact send it. And thirdly, the message was not sent with the authority of the principal expressed or identified in the message. So this is where the addressee has actual notice of these matters. Subclause 3 clarifies that an addressee who has actual notice of the matters mentioned in subclause 2 may nevertheless rely on the message if at the time that they received the actual notice, it was not practicable for them to stop the processing of the message. And subclause 4 clarifies that an addressee who is permitted by clause 21 to accept any matter is not liable to any other person by reason of relying on the matter.
江玉歡議員。
主席，我有一個問題關於subclause 2嗰度。嗱，subclause 2嘅咧第5行就話咧要有 actual notice 嘅。咁我想請問一下，呢個係咪唔會包 constructive notice？ 咁如果係唔包嘅話，其實嗰個原因點解係唔包，只係可以有 actual notice 咧？咁第3咧，我想請問一下嗱，第3出現一個 scenario 咧好特別嘅，主席就係話當嗰個 addressee 咧。其實佢就算知道1都好啦，佢已經冇嗰個即係唔 reasonably practicable， 俾佢 stop 去到 process 嗰個有關嘅 message。想請問呢一度可唔可以 explain 一啲 scenario， 即係俾一啲 scenario 我哋睇一睇點解會去到3呢種情況呢？係因為3就咁睇咧，就咁睇就覺得即係大眾嘅市民可能有啲驚嘅。如果咁嚇，你搞唔切就會繼續去到，就算你知道都好啦，你都會繼續去。咁我想請問點會發生呢種情況呢？
係證監會。
Yeah, so thank you for those questions. The intention is that it includes actual notice. The reason for that is if we are allowing, or rather if we are depriving the addressee of the ability to rely on the message, it is important that the notice that the reasons for that is that it actually knows that they should not be relying on that notice. So for that reason, we have limited that to actual notice and not included constructive notice. In terms of your scenarios for subsection 3, subclause 3, we don't really have specific scenarios in mind. The provision is really there to allow for the possibility that this might have happened, that when the addressee sent the message, they didn't have that awareness. But it might be, in the event that subsequently they did, and there's something they can do about it, we would want them to take steps. There is a balance here between wanting the transactions to go through as quickly as possible and how quickly they actually go through. So if they haven't actually gone through and the addressee somehow has notice of something in the message that is inaccurate, then it should not be able to allow that transaction to go through. The idea is really to strike a sort of balance between the rights of both parties while also allowing transactions to go through efficiently and quickly.
OK， 可以繼續。證監會。
Right, we move then to part 5, which is dematerialization on request of an investor. So clause 22 deals with dematerialization of prescribed securities at the request of a registered holder. Subclause 1 delineates the scope of clause 22. It notes that it only applies where the securities are participating securities and held in certificated form. Subclause 2 provides that the issuer may dematerialize such securities at the request of a registered holder, and it sets out the prerequisites for doing so. Subclause 3 clarifies when the requirement to receive title instrument doesn't apply. Subclause 4 to 6, these describe the issuer's obligation upon receiving a DMAT request. So these are that the issuer must, as soon as reasonably practicable, decide whether to accept or refuse the request. And if the request is accepted, the issuer must dematerialize the securities and cancel the title instrument. And if the request is refused, the issuer must, as soon as reasonably practicable, notify the holder of the refusal and give reasons. Subclause 7 notes that breach of the issuer's obligations under this clause without reasonable excuse is an offence, and it sets out the applicable penalties.
江玉歡議員。
主席，我想請問一下咧，就係喺第4嗰度，嗱呢個即係無紙化嘅 request 啦嚇，即係可以咁講，咁咧就要 as soon as reasonably practicable 咁樣進行。即係仲有即係話，如果唔得 accept 或者 refuse 個 request 咧，都要係合理時間內進行。咁我想請問一下，點解唔可以 impose 一個 time limit 咧喺呢一度？即係我作為一個市民，好啦。另外啦，呢個同我第7嗰度嗰個問題有關聯嘅。嗱，第7咧你就話，如果佢唔符合10 Rule 4去做 contravene 咗10 Rule 4咧，佢就有一個即係除咗話有一個 fixed fine， 佢仲可以有一個 further 嘅 daily fine。嗱，我就喺度諗啦，4如果你都冇一個限期，嗰只係盡快做咯。咁你點7你點可以罰佢每日罰款咧？即係我唔明啊！即係當你冇指明佢要幾耐之內去做，你點可以有一個 further fine for each day that the offence continues 咧？
證監會。
Yeah, thank you for that question. So on the issue of why there is no time limit, the reason is because if we were to set a time limit, it would be in days. And in certain cases, you may not need days. And so the idea is that the issuer needs to do this as quickly as possible. That's really the main reason for not putting in a day. The code, however, does elaborate on what is absolutely maximum. So we strike a balance that way. In terms of the daily fine, our understanding, or I should say my understanding, maybe Mr. C will expand, is that it is for the court to decide what day, from which day to count the daily fines. I don't know if Mr. C wants to.
先生有冇啲咩補充？
主席，多謝江議員嘅提問。咁頭先 Miss McCallum 嗰個解説都係正確嘅。咁因為我哋就算係一個所謂佢個罪行元素有一啲所謂合理嘅，即係究竟係咪 reasonably practicable？咁最終法庭喺定罪嘅時候，佢都需要咧係定出一個，即係佢要有個決定，就係幾時先為止係一個合理嘅時限。咁由嗰日開始咧，佢先至可以去計係咪有個即係持續嘅罪行咁樣咯。
主席，我呢度個 note 啫，我唔係話要改下，即係我自己覺得就好嘥法庭時間咯。嗱，你唔擺一個話，即係你唔講話咩為之係合理，跟住你就叫法庭去到定700蚊，即係如果係即係罰咧就700蚊一日啦。坦白講咧，邊個會打上去法庭就因為你遲嗰2日咧，係咪先？但係唔係喎，如果你喺呢啲 law 裏邊你寫到明佢要幾多日之內做，我作為一個消費者，我作為一個投資者，我就知道佢係錯啊定唔係錯，就唔需要去法庭嗰度叫法官去到定咩叫做 reasonably practicable。我覺得咁樣好浪費法庭嘅時間。呢個我個 note 嚟嘅，主席嚇，唔該。
不過理解係咪個指引或者係個守則入邊有一個實際嘅一個日數係咪啊？啱啱我聽到。
Yeah, thank you, Mr. Chairman. There will be something in the code, also because we might want to keep that time as short as possible. So over time, we might want to shorten it. So we want to have that flexibility for keeping it in the code. At the beginning of implementation of USM, the share registrars may need a bit more time to sort of make accommodations. So that's why we've taken this approach. So there will be certainty as far as the investor is concerned.
好，主席，我希望呢，即係政府當局能夠到時俾市民多啲嘅指引，好嘛？因為普通市民睇條 law 或者點樣，佢真係睇唔到嘅，好嘛？唔該。
好，譚廣恒議員。
謝謝主席。就是第22條第6款呢，就是如果發行人決定拒絕去實物化的請求，因為我們整個這一條是說請求去實物化，那麼就會結束它去實物變成無紙化。但是現在這裡還是有發行人有的情況下面是可以決定拒絕去實物化的。我看了前面的內容的話，那可能就是說這個證券是不現實的，現實的並不存在的，或者是這個證的權益是很有問題的這些情況。如果是一種正常的情況，是不會拒絕它去實物化，是應該接受它的無紙化的。那如果是有這種情況，就是要拒絕去實物化，接下來會是怎麼一個處理呢？因為我們並不想一直拖着這個證券中的有一些成分是實物的方式存在，我們是想追求100%的這個無紙化的存在，所以對這一些拒絕去實物化的，接下來會是什麼的處理呢？
係證監會。
Yeah, thank you very much for that question. So, a very valid question. Actually, we don't expect the issuer to refuse the dematerialization. The one scenario we can think of is where the certificate itself is questionable, where there is suspicion that the certificate itself is fraudulent, in which case they would be entitled to refuse to dematerialize the securities. And in that case, what will happen is that the whole shareholder base will be protected because nobody wants a fraudulent certificate to be dematerialized and inflate the total shareholder volume.
OK， 冇其他跟進嘅話，咁啊證監會可以繼續。應該去到23。
Right. Thank you, Mr. Chairman. So moving on to Clause 23. Clause 23 deals with the dematerialization of prescribed securities at the request of a transferee. So subclause 1 delineates the scope of Clause 23, and it notes that it only applies where the securities are participating securities held in certificated form and where the issuer has received a request to register a transfer of them. Subclause 2 provides that the issuer may dematerialize such securities at the request of a transferee, and it sets out the prerequisites for doing so. So this includes that the transferee must be a system member, that it has received a dematerialization request and the relevant title instruments, and that the issuer is satisfied that the transfer may be registered. Subclause 3 clarifies when the requirement to receive title instruments doesn't apply, So this is where the governing provisions do not require such instrument to be issued, or where the issuer is satisfied that the instrument is lost or damaged. Subclause 4 clarifies that the disapplication of the requirement to receive title instruments, a title instrument that is lost or damaged, does not extend to other instruments that are not lost and damaged and that have to be submitted for the purposes of the DMAT request. Subclauses 5 to 7 describe the issuer's obligations upon receiving a DMAT request from a transferee. So it's again, the issuer must as soon as practicable decide whether to accept or refuse. If it accepts, the issuer must as soon as reasonably practicable register the transfer, dematerialize the securities, and cancel the instrument. And if the request is refused, the issuer must notify the transferee of the refusal and the reasons, and refuse to register the transfer. Subclause 8 notes that breach of the issuer's obligations without reasonable excuse is an offence, and it sets out the applicable penalties. Moving then to Clause 24. Clause 24 simply deals with the form of a DMAT request. If that's okay, we'll move on to Part 6. Part 6 deals with the issuer's authority to dematerialize, rematerialize, and issue new units in uncertificated form. Clause 25 deals with the dematerialization of prescribed securities at the initiative of an issuer. Subclause 1 delineates the scope of Clause 25, and it notes that it only applies where the securities are participating securities and held in certificated form. Subclause 2 provides that the issuer may, at its own initiative, dematerialize securities if certain prerequisites are met, and they are basically one, that the holder or prospective transferee is a system member, and secondly, that the issuer has received the relevant title instruments. Subclause 3 clarifies when the requirement to receive title instruments doesn't apply, and as with the earlier provisions, it's where the governing provisions do not require instruments to be issued, or where the issuer is satisfied that the instrument is lost or damaged. Subclause 4 expands on some of the circumstances in which an issuer may dematerialize securities at its own initiative. It is not an exhaustive list. Subclause 5 describes the issuer's obligations if it decides to dematerialize the securities at its own initiative. And these are that the issuer must, as soon as reasonably practicable, dematerialize the securities and cancel the instruments. Subclause 6 notes that breach of the issuer's obligations without reasonable excuse is an offence, and it sets out the applicable penalties. Clause 26 deals with the issue of new certificates, with the issue of new units of securities in uncertificated form at the initiative of the issuer. Subclause 1 delineates the scope of the clause. Subclause 2 sets out the prerequisites for issuing new units in uncertificated form. Subclause 3 describes the issuer's obligations when issuing new units in uncertificated form. Moving then to Clause 27, this deals with the rematerialization of prescribed securities in limited circumstances. Subclause 1 delineates the scope of this clause. Subclause 2 describes the issuer's obligations, namely that the issuer must rematerialize any units that are in uncertificated form before they are delisted, and if their governing provisions so require, they must issue title instruments as soon as practicable thereafter. Subclause 3 clarifies that any title instruments issued to a recognized clearinghouse or its nominee must be in such number and denomination as specified by the clearinghouse or nominee. Subclause 4 notes the issuer's obligation to include certain further matters in a notice sent under Clause 6, and these are to clarify that the title instruments are to be issued following the rematerialization, and if so, when and how such instruments may be obtained. Subclause 5 notes that breach of the issuer's obligation under this clause without reasonable excuse is an offence and sets out the applicable penalties. Moving then to Part 7. Part 7 deals with facilitating the market's transition to full dematerialization. Clause 28 sets out the various mandatory obligations to be imposed on issuers. Subclause 1 mandates that all existing prescribed securities constituted under the laws of 4 key jurisdictions must become participating securities by the deadline specified in respect of them, or within 5 years of USM implementation, whichever is earlier. Subclause 2 mandates that all prescribed securities constituted under the laws of the 4 key jurisdictions and first listed after USM implementation must be in uncertificated form from the time of their listing or such later date as permitted under this clause. Subclause 3 mandates that subscription warrants and rights under a rights issue must be participating securities by the time they are listed if at the time of their issue the underlying securities are participating securities. Subclause 4 relates to subclause 1 and clarifies how the deadline for existing prescribed securities is to be set. Namely, it is to be set by the corresponding parties, or if they fail to do so, by the SFC. And it is to be specified by notice in writing to the issuer. Subclauses 5 and 6 relate to subclause 2, and they clarify the prerequisites for deferring the deadline for IPO securities to become participating securities. These are that the deferral is by the SCHK and only possible within the first year of USM implementation. And secondly, that the SCHK must be satisfied that there are exceptional circumstances justifying deferral and that not granting deferral will unreasonably delay the intended listing date. Subclause 7 sets out a list of some of the factors that may be taken into account when deadlines are specified in respect of existing prescribed securities or IPO securities. Subclause 8 clarifies the deadlines may be revised or cancelled in the same manner as they are specified. Subclause 9 notes that breach of the mandatory obligations under subclauses 1 to 3 without reasonable excuse is an offence and sets out this applicable penalty. Subclause 10 expands on the meaning of terms used in clause 28.
江玉歡議員。
你呢個28咧好重要啦，即係成個 transition 個 provision。我想請問一下喺第9嗰度咧，你哋講話個 issue 啊，即係如果佢冇一個 reasonable excuse，OK， 咁佢就犯法啦。咁我想請問一下，呢個係佢必然要做嘅嘢啦，係咪？咁你可唔可以解釋下咩為之係一啲 reasonable excuse 佢可以唔做咧？1、2、3。
證監會。
Yeah, thank you for the question. So it's really to allow for any intervening events that may have occurred and that may require some change in the timeline or that may make it unnecessary for the offeror, for the issuer to participate in USM. An obvious example would be if between the time of the date for the issuer being specified and the actual date, for whatever reason, the issuer has to delist. So that would be an obvious example where then it's no longer meaningful to proceed with this.
Okay, 繼續。
So we move then to clauses 29 and 30. These impose restrictions and obligations in respect of prescribed securities that have become participating securities. Clause 29 prohibits the further issue of new units in certificated form. It also makes breach without reasonable excuse an offence and sets out the applicable penalty. Clause 30 prohibits the further issue of title instruments, and it makes breach without reasonable excuse an offence and sets out the applicable penalty. Clause 31 requires all units of those securities held within CCAS to be dematerialized within 6 months of the securities becoming participating. Again, it makes breach an offence and sets out the applicable penalties.
江玉歡議員。
主席，我想請問一下喺29同30咧，嗱29同30都係好有道理嘅寫得嚇，即係話如果咁樣進行嘅時候咧，嗱新嘅發行咧就唔能夠再以紙形式啊等等。29同30嚇各有佢嘅道理。咁但係29同30，我想問點解要有每日嘅罰款咧？又嗱佢唔做就唔做啊，或者你唔想佢咁樣做係咪？理論上唔應該有 daily fine 嘅喎，我自己覺得係咪合適咧？想請問點解會有咁咧？
Thank you for that question. So the daily fine is really just an added incentive, an added deterrent against breach. So the way we think about it is that it's bad enough that they don't comply, and the longer they wait, then the more they should be penalized. That's the logic.
咁即係話，主席，即係話嗱，你譬如29啦，你唔想佢再發行紙本啊，即係如果佢繼續咁樣發行，你就斷日咁樣再罰佢啦，係咪
？That's correct. Yeah.
OK， 唔該。
OK， 可以繼續。
So we come then to the last section of these rules, which is Clause 32. So Clause 32 provides for exemptions from the obligations under Part 7. Subclause 1 exempts securities that are in the process of delisting. Subclause 2 empowers the SFC to exempt or defer an issuer's obligations under Part 7. Subclauses 3 to 5 expand on the SFC's exemption power. Subclause 6 expands on the meaning of the term specified person.
法律顧問有個補充，時間交俾你。
係，多謝主席嘅。咁就住呢個無紙證券市場規則啦，即係第15號法律公告呢，有個概括性嘅補充俾翻議員察悉嘅。咁喺第15號法律公告底下呢，有13項嘅新罪行嘅。咁呢啲新罪行呢，都冇明文規定到呢，需唔需要證明呢個犯罪意圖嘅。咁我哋法律事務部曾經同當局作出個書面查詢啦，咁就問佢哋呢啲罪行係唔係嚴格法律責任罪行嚟嘅。咁即係控方無需證明有干犯呢啲罪行嘅犯罪意念元素。咁而當局回覆亦都表示咧，呢啲罪行咧係嚴格法律責任罪行。咁咧佢哋認為，因為呢啲係規管性質嘅罪行，而且咧施加嘅罰則輕微咧，所以佢哋都會係個立法原意都會係一個嚴格法律責任罪行嘅。咁呢個補充資料俾議員參考。多謝主席。
好，唔該。證監會係可以繼續。
Right, thank you, Mr. Chairman. So we then
唔好意思，簡慧敏議員。
係主席，我想問我哋而家係咪即係呢個 part 即係第7部分過咗啦？係咪啊？即係已經32條都講咗啦 ，exemption 嗰度嚇。啱
啱完咗第7部分係。
係，我想問個 schedule 嗰度，即係個附表咧，就係有邊啲地方而家咧係指明咗係嗰個地方嚇？係即係話我哋無紙化適用嘅一啲嘅地方啦嚇。咁而家就係百慕達啦、開曼群島啦、香港啦，同埋中國內地嘅。如果要修改呢個 schedule 係喺邊度定明啊？我想睇睇。
證監會
即係討論政策嘅時候有提過話，譬如話喺將來英國係就緒，或者邊度地方係就緒嘅話，會喺呢度加入去嘅。會係點樣做咧？請問。係，
或者證監會師生係咪？
係。係，多謝主席，多謝簡議員嘅提問。咁如果要修改呢個USM Rules 個附表咧，咁就會用翻即係本身我哋訂立呢個 USM Rules 嗰個賦權嘅條文，咁就係由證監會都係透過negative vetting 嘅形式訂立一個修訂規則去修改嗰個附表嘅。
即係到換句話嚟講，因為呢樣嘢去實施就即係預計啦嚇，因為而家仲時間未真係完全確定，就係去到2026年初，咁可能中間呢段時間仲有啲其他地區啊，仲會進行一啲討論。咁假如有啲咩改動嘅，咁你哋當時都即係好似相類似而家呢個咁樣嘅狀態，係咪啊？即係如果過咗當時真係實施之後咧，咁可能又要即係做一啲OK， 明白。應該有冇
可唔可以俾一俾嗰個你講 SFO 嘅邊一條啊？即係你話根據 SFO 邊一條可以去增加，或者即係亦都包括減少係咪咧？定係你呢個會唔減少咧？因為即係大家都預咗係呢4個地方。
係咁就係即係我哋之前討論嗰個2021年修訂條例入面咧，加入去證券及期貨條例裏面第101 AAM 條嗰度就賦權證監會去訂立規則嘅。係。
等下101 AAM， 即係21年嗰條，即係當時嘅第17號條例，第17號條例2021就係授權咗證監會訂立規則。訂立規則邊一度啊？可唔可以即係明確少少？即係101 AAM。
如果係就住無紙化嗰啲咧，咁就會係101 AAM 嘅第一款入面 A 嗰啲，即係涉及或關乎定名證券嘅活動及事宜。咁入面最尾嗰度就有就係3，就係將定名證券由有紙形式轉換成無紙形式，或者相反啦，同埋利便同促進定名證券電子用途啦，同埋最尾J 即係下一版啊，即係第2款嘅 J 嗰度就係定名過渡至定名證券全面去實物化，包括定名證券去實物化設定時間表同期限，以及其他方式控制定名證券去實物化的進程咯。即係再重複多次就係101 AAM 嘅1A 同埋2J 咁樣咯。
主席，我就留意到2J 咧就冇特別提到個地方嘅，即係話過渡至定名證券全面去實物化，包括為定名證券咧去實物化設定個時間表及期限。即係頭先主席你提到嗰個而家嘅時間表就係初定係2026啦。咁以及以其他方式控制定名證券去實物化的進程咁樣嚇。邊度提到話係邊啲係納入嗰個適用嘅地方咧？
我諗呢個就真係成個點樣，即係呢個 J 就其實賦權係有一個好大嘅空間，就係究竟係我哋點樣去制定個時間表，包括係究竟係即係 by reference to 地方啊，同埋係一個咩嘅時間表。咁我諗呢個就係一個好概括嘅賦權，就係俾證監會去定，即係制定嗰啲過渡嘅細則咯，係。
咁點解你唔喺呢一度去講呢度嘅 schedule 嗰啲嘅地方係可以嚟到去修訂咧？因為第28條嗱呢一度咧個 rule 上邊即係嘅附表啊，主席就喺嗰度有個方括弧係指住 rule 28咁樣，係第28條。咁喺28條嗰度邊一度講喺28條佢係可以去調節嗰個地方啊？
關於即係調節一啲制定附屬法例嘅原則，其實喺釋義及通則附例入面咧，有一個即係概括嘅條文，關於附屬法例嘅，咁就係第28條，即係第1章第28條嗰度，佢就係話可以第1章第28條第1C 款嗰度，佢就係話咧。任何嘅附屬法例咧都可以由相同嘅人士透過訂立時候嗰個方式去修訂嘅。咁所以咧就整體而言嗰啲賦權條文就好少再講話將來你又可以改咁樣咯，係。
或者即係你呢度喺邊度引用呢個 schedule 咧？即係喺呢一個規則自己本身邊度引用呢一個附表？邊一條引用？
係。規則本身引用呢個附表咧，如果睇翻個附表，通常我哋右上角嗰度就會有個即係方括號就講咗引用個附表嘅條文嘅。咁喺呢度咧就係第28條咯，即係 USM Rules 第28條嗰度就引用咗個附表，因為28條就係頭先一開始講嗰個即係幾時係需要作為一個參與證券啦，即係參與落去呢個無紙化制度嗰度係啦。
係邊一條啊？28條我睇到，所以頭先我自己都指出咗呢個第28條。第28條嘅邊一條10 rule？
係或者係證監會穆小姐
Can take that question. So the way Rule 28 works is that the term specified prescribed securities is used in clause 28.1 and in clause 28.2. So those clauses start with the issuer of any specified prescribed securities. And then in clause 28.10, there is a term specified prescribed securities, which is then defined by reference to the schedule. Hence the reference to section 28, to Rule 28 in the schedule itself.
好，我諗因為時間係啦，即係差唔多。如果你有啲咩再跟進，可以消化咗，再作出提問嚇。我諗再繼續啦，可以係證監會時間交翻俾你繼續啲條文審議。
So I think that takes us to the end of the USM rules. So we can perhaps then move to the ASR rules, so the Securities and Futures Approved Securities Registrar rules.
Okay.
So we'll start with Clause 2, I suppose. Clause 2 is the interpretations provision, and it sets out various definitions used, various terms used in these rules. The first definition is available liquidity, and this essentially refers to the liquidity, the available amount of assets that are readily available to an approved share registrar. Approved securities registrar, I beg your pardon. The term capital is defined to include the share capital and retained earnings of the registrar. The term corresponding exchange company is defined by reference to the stock market listing rules. Essentially, it refers to the exchange company on which the securities are listed or to be listed. External borrowings is defined to refer to the amount calculated in accordance with the formula set out in the definition. Gearing ratio is again defined to refer to the percentage calculated in accordance with the formula set out in the definition. Issuer is defined in relation to any prescribed securities by reference to the USM rules. Issuer client is intended to refer to clients of an approved securities registrar that are issuers. Maximum gearing ratio refers to the percentage mentioned in Rule 83C, which we will come to. Minimum capital level refers to the amount mentioned in 83A, which again we will come to. Minimum liquidity level refers to the amount mentioned in Rule 83B, which we will come to. All of these definitions relate to financial resources requirements to be imposed on the ASR. Securities holder refers to the person who is or was entered in the register of holders as holding the securities. Securities registrar takes the definition from the stock market listing rules. Essentially, it refers to the person who keeps the ROM, who keeps the register of holders. Senior employee is defined by reference to Section 101 AAG 8 of the SFO. This again is introduced under the 2021 Amendment Ordinance. Service facilities refers to electronic facilities used by the ASR in providing securities registrar services, and it includes the UNSRT system. Surplus liquidity is defined to mean an amount calculated in accordance with the formula set out in that definition. Third-party money refers to money received by or on behalf of the registrar for a third person. Total operating expenses refer to the operating expenses and financing costs. And in these rules, there are references to an approved securities registrar's business and operations, and we clarify that this refers to their business and operations as an ASR.
講到呢度，我想提問呢，就喺定義入邊，因為有唔同地方會提及呢個高級僱員同埋高級人員，你可唔可以約略講下呢兩種類別嘅分別啊？嚇，唔該。
So senior employee. Sorry, just give me a second, Mr. Chairman.
可以。
So senior employee refers to a person who is employed by the applicant and who performs supervisory or managerial functions. In contrast, senior management refers to the people who are actually managing the operations of the ASR, so the sort of the directorate board and the more senior persons, if you like.
即係兩個都係高級，不過即係一個更高級咁樣係咪咁理解？
I think the thing is it depends on the particular ASR. In some cases, if it's a small operation, they might overlap. If it is not, they may not. So it depends.
明白。OK， 可以繼續。好。
We turn then to clause 3, which is the specification of securities registrar services. So the term securities registrar services are the services that require an ASR approval if the person is going to provide it. 2 of those services are already listed under the SFO, and so clause 3 adds 2 additional services. One is the service of provided in connection with a public offer. It's where the share registrar makes available an electronic platform to accept applications and in an IPO. And the second service is where the share registrar provides corporate action related services. Subclause 3 includes some definitions, which corporate action, it basically defines it to mean any action taken or to be taken by the issuer. So it would include things like dividend issues, a rights offer, things like that. And public offer is defined to mean an offer of securities to the public for purchase or an invitation to the public to make offers to purchase those securities. Moving then to part 2, which are the general requirements. So the requirements relate to the ASR's premises, service facilities, management and governance, and insurance coverage. Clause 4 deals with the premises and essentially requires that the premises must be suitable, adequately and properly equipped, and where the premises are used for processing or storing information or data, they must be equipped for maintaining security, integrity, and ready accessibility. Clause 5 deals with service facilities, and the requirement there is that its service facilities must be equipped with adequate capacity, contingencies or facilities to meet contingency or emergencies, security arrangements, and technical support. Clause 6 deals with management and governance. This requires that the ASR must have competent personnel, effective internal control procedures, effective contingency measures, and business continuity arrangements. Clause 7 deals with insurance
我諗
coverage.
停一停，江玉歡議員。
係主席，對唔住，我慢咗少少。我想請問喺第4嗰度咧 ，premises 有冇只係一定要喺香港，定係唔需要一定喺香港嘅
？We don't have a specific requirement that the premises should be in Hong Kong. However, in the ASR code, we do require certain things to be operated from Hong Kong. The reason is that some of the share registrars, they are rather global groups, so some of their premises might be located overseas. But the concern from our perspective is that if something needs to be done, if something needs to be followed up, if something needs to be communicated to them, people in Hong Kong must be there. And if they're not there, then whoever is overseas must be able to be contacted during Hong Kong hours. So that's the approach we take, and that's expanded in the ASR code.
OK， 咁個 ASR code 咧，想請問主席係咪已經係 ready 㗎啦？你哋即係有
Yes,
OK，
it's there.
Thank you。
OK， 仲簡委民議員。
主席，我想睇一睇嗰個服務設施嗰度咧，因為而家我哋講緊嘅 premises， 跟住就係個服務設施第5條啦。服務設施嘅第5條咧，喺個定義嗰度咧，就有提到話係就住個 ASR 嚟講咧，就係嗰個包括 UNSRT 啦。我呢度咧亦都想咧，即係話如果有啲嘅定義啊，用起上嚟方便我哋審議咧。如果係喺21年嗰個條例通過咗嗰度已經用過嘅咧，可唔可以方便我哋？你下次帶即係喺個 slide 度打翻佢出嚟，方便我哋睇，或者你而家講咧係喺邊度？喺21年嗰條條例 UNSRT 係點樣定義嘅？然後咧就係、但係就唔一定係用佢㗎嚇。呢度係 including 即係包括呢個 UNSRT 嘅系統。咁亦都係不論咧呢一個嘅 facility，sorry， 我而家睇緊英文版嚇，係由嗰個 registrar 擁有或者係由佢使用，點解啊？即係呢個 service facilities 你呢度又唔係一定要佢用嗰個 UNSRT system 嚇，解釋一下唔該。
Thank you for that question. So the term UNSRT system is defined in Section 101 AAB of the SFO, which is added under the 2021 Amendment Ordinance. And that definition actually refers specifically to the system for enabling title to be evidenced and transferred. So the definition as such does not encompass all the other functions of an ASR. So an obvious one would be where the ASR provides electronic public offer related services. So if they have an electronic platform to receive applications in an IPO, that would not be the UNSRT system, but that would also be a service facility that we want to have regulatory oversight on. So hence the definition being broader than just UNSRT system.
咁係咪即係你嗰個最開始個 PPT 介紹嘅時候嗰個 USI facility 啊？嗰個係乜嘢系統啊？
So when we talk about the USI facility, what we mean is the platform for the investor to access the share registrar's system in order to manage and view their holdings. So that would be part of the computer systems and facilities of the ASR.
咁即係主席嚇，即係點咧？即係而家呢個系統存在咗未咧？介紹多少少關於呢一個系統，咁同埋點解會用嗰個字眼係不論係唔係佢擁有或者係佢使用嘅系統咧？
So the share registrars are in the process of developing their systems and building them. The intention is for them to have their systems ready by the time of USM implementation, which is currently targeted for January 2026. As to your question about why the definition of service facilities includes facilities whether or not they are owned or used by the registrar, this is to allow for the possibility that the systems may, to some extent, be provided by a third party, either within the group or by someone outside the group.
我對嗰個使用有啲覺得奇怪啦，即係你話不論該等設施是否由該機構擁有，就或者係咪？即係可能係個集團或者係，因為其實即係好似最初SFC 代表所講啦，即係大嘅我哋都知道係嗰幾間啦。咁但係亦都可能係嗰個系統未必係嗰個實際上呢個 ASR 嘅擁有。咁但係點解連使用都排除埋咧？佢梗係要使用嗰個系統㗎，係咪可以不論該等設施是否由該機構擁有就可以停咗佢咧？唔係太明白。即係
你個問題係。
即係佢定義乜嘢係為之嗰啲服務設施啊嘛。咁個服務設施就係話包括嗰個 UNSRT 啊。咁你包括明，因為你仲有其他嘅系統，所以你用包括。咁但係點解要不論該系統是否由該機構去擁有或使用咧？即係佢一定會使用㗎嘛。
即係最起碼會使用啦，係咯。即係佢唔係佢擁有，又可能係一個外判咗出去，但係使用就照計應該佢都會使用嚇。
Mr. Chairman, may I take this one back? I'm sure there's a reason for it, which I can't recall right now, I'm afraid.
證監會史生係咪有
The words the facilities are owned or used by the share registrar.
要蕭小姐開翻咪要幫。
Service facilities, whether they are used or owned by the share registrars, allow for the possibility that the share registrar may subcontract out the operations, the facilities that they are using to provide the services.
但係就算外判出去咧，你都喺度使用緊啊嘛。即係如果你話唔使用，即係如果你話唔係佢自己擁有嘅，可以理解，但係唔係使用就似乎好似諗唔到有啲咩情況。
We can come back on this issue. Thank you.
呢個或者係啦，可以我諗要注意呢個係呢一點啦嚇。好，唔該。OK， 好證監會可以繼續。第6點、第7點，啱啱講到第6、第7咁樣，應該係咪
？So Clause 7 deals with the insurance obligations of the ASR. So the requirement is that the ASR must ensure that it is covered by insurance that is reasonable, that is necessary to provide reasonable protection against risks associated with its business and operations. And the subclause 2 goes on to expand on this to some extent.
係江玉歡議員。
問下呢個2嘅 A 嗰度咧，話有關嘅保險係需要包埋以前嘅一啲員工。我想請問呢度有冇限制嗰啲員工係要離開咗公司幾耐嘅？會先。
證監會。
Thank you for that question. There is no limitation that we have in mind for that.
Okay. Thank you.
OK， 可以繼續。
Moving then to part 3, which is the financial resources. So clause 8 provides that the ASR must at all times maintain financial resources that comply with requirements specified under this rule or amended under this rule. Clause 2 provides that the Commission may, by notice in writing, specify financial resources requirements. Subclause 3 provides that these financial requirements imposed by the SFC may include requirements relating to the ASR's capital, relating to the ASR's available liquidity, and requirements relating to its gearing ratio. So the gearing ratio is the ASR's external borrowing over total equity. Subclause 4 talks about the Commission's power to amend or revoke financial resources requirements imposed under this rule. Clause 9 talks about notifications regarding financial resources. This provision is really intended as a requirement for the ASR to notify if their financial resources fall below certain levels or certain financial related events occur in relation to their business. And the idea is that if these triggers are hit, then the SFC can monitor their financial position more closely.
簡慧敏議員。
主席，我想問8.3B 嗰度咧，就講個 liquidity ratio 嚇，即係個流動資金咧，因為呢個都影響嗰個 ASR 佢嗰個經營啊，同埋佢啲合規嘅一啲嘅指數嚇。呢度就提到咧，就話相等於該機構喺某指明月份數嘅數目嘅期間嚇。咁呢個指明月份數點解唔可以喺呢度明確係同埋係咪由 SFC 去因應每一個 ASR 去定佢個 liquidity 嘅即係佢個流動性嘅要求啊？即係佢有幾多嘅能夠去 total operating expenses， 即係佢個營運開支乘以幾多個月啊？呢個幾多個月就唔知道業界有冇訴求係想即係明確啲，定係因應唔同嘅 ASR 會定唔同嘅標準俾佢咧？
Yeah, thank you for that question. So the answer is yes. The idea is that a single number of months may not apply across all share registrars given their different size and scope of business. And so this gives us the flexibility to specify different amounts for different operations.
不過我諗跟進翻簡議員講呢個，首先個營運成本係幾多？可能你對比於佢自己嗰間公司會比較一個相對嚟講固定，但係如果你話幾多個月份都比較有一個闊嘅可能長可能短，咁嗰個數字都可能幾唔一樣嘅。咁我唔知會唔會有啲譬如守則嗰度會再進一步講呢啲嘢咧，抑或係好似我聽到簡議員講個淨係嗰個
即係有冇個確定性？
係啊。
幾時先會通知佢咧？即係個 ASR 係佢攞到你個 approval 嘅時候就知道啊，因為叫 approved 㗎嘛嚇。咁佢嗰個被你核准嘅時候就知道佢往後嗰個流動性係要定喺幾多個月嘅 OPEX 嗰度，係咪都喺嗰陣時會確切，定係都可以變嘅咧？呢個嚇唔該。
Yeah, thank you for that question. So in terms of when the share registrar will be informed, it will be informed at the time of its approval. And if there is a change, it will be informed when we instigate a change. I should just add that the number of months, the idea of the available liquidity requirement, a number of months, is to look at the operation and take a view on how long would it take to wind down that business if it became necessary. So the idea is that we want to make sure that if for whatever reason the ASR needs to wind down its business, the winding down can be done in an orderly manner. And so we must make sure that there is enough funding in order to achieve that. So the duration may differ for different share registrars depending on the size of their business, the scope of their business. There may also be share registrars who are only acting for themselves or only acting for one company. So the requirements would vary quite significantly.
主席，所以同樣地，即係 A 嗰度對佢個資本嘅要求啦，或者係佢個 gearing 啊，即係嗰個槓桿比率咧，都係因 registrar 而定啦。
That's correct.
OK.
Yes.
唔該。
OK， 可以繼續。
So I think we've got to clause 10, right?
Okay.
So clause 10 expand.
江玉歡議員。
主席，因為我9嗰度有嘢問，對唔住。想請問翻9咧，嗱9嘅2咧，其實羅列咗一啲好重要嘅事件咧，其實呢個 ASR 係應該盡快通報嘅。嗱，咁但係2嘅寫法就係話佢就要盡快啦，同埋係 in any event within 1 business day after becoming aware。嗱，我想問啦，即係話佢要係察覺先得。咁如果我想問，如果佢扮佢自己唔察覺咧，嗱，譬如嗰啲好重要嘅喎，講緊個 liquidity 嘅噃，咁你點樣保障公眾咧？想請問，如果佢話佢自己唔察覺，嗱，第二樣嘢啦，即係佢應該察覺㗎嘛，佢實質佢唔察覺，但係佢應該可以察覺㗎喎，係咪？咁點解呢度淨係寫話佢係要 becoming aware 咧？咁嗱，另外咧，主席，我想問清楚啦，嗱。第9嗰度你講咗一連串就係話，當佢嗰個財務狀況、財政資源有問題嘅，呢個先係好核心嘅。嗱，你就要求佢盡快啦in any event 1個 business day after 佢 becoming aware。但係嗱，去到一陣間 Rule 18嘅時候咧，講有一啲 reportable matters， 包括就即係可能佢有啲服務設施事故或者有啲營運事故嘅時候咧，哇！你又要求佢咧 immediately after 佢哋 becoming aware。嗱，我想請問一下，點解喺9你就要求佢知道，總之佢知悉啦within 1個 business day， 反而喺當你報到 reportable matter 嘅時候咧，一啲營運事故咧，你就要佢 immediately after becoming aware。其實呢一度你點樣去到拿捏？有咩點解會有咁嘅分別咧？想請問。
證監會。
Yes, thank you for that question. The reportable matters relate to matters concerning their service facilities or operations. So if a reportable matter arises, its impact on investors is immediate. So for example, it may be immediately impossible, just by way of example, for investors to effect transfers. So even while the share registrar or the securities registrar is working on a solution, we want to be in the loop. We want to know that, look, something's happened so that we can monitor the situation, and because investors may also approach us directly. And so we are in the loop as early as possible. So the need for immediacy is there. In the context of the financial resources requirements, some of the levels here are sort of not yet at the levels that we have dictated, so they are slightly above. So they're close to breaching but have not yet breached the financial resources requirements. So I suppose you could think of it in terms of the immediacy is not that great, but we still want to be informed as soon as possible. So you were also asking about, their becoming aware. Our understanding is that securities registrars should know what their financial position is at all times, and because there are requirements in terms of how the different lines of business are overseen and overseen and managed. So we do expect senior employees or certain staff to be aware of these and therefore be able to inform us as quickly as possible. We do not envisage persons who are approved as ASRs to not be aware of what their financial situation is.
好，主席啊，咁如果根據頭先解釋咧，即係話其實因為先呢即係嗰啲 management 佢係應該要知嘅，所以 becoming aware 應該係包括埋 they ought to know, right?
We haven't chosen that language. We have relied on language that they are actually aware. I think if you start talking in terms of ought to know, we would be in a bit of a bind as to how to prove it. I mean, on what basis would we say that they ought to know? So, and the obligation here is on them. So once they are aware, the obligation is that they need to notify us.
OK， 簡慧敏議員。
主席，你最在行啦嚇，即係關於證券行業啦嚇。我呢度睇到嗰個相關嘅問題咧，同江議員提出都類似嘅，即係你呢度淨係用 becomes aware 咧，就係即係等於 actual knowledge 啦，即係佢一定要實際上自己知道啦。咁我都明白，因為嗰度嗰啲嘅 ratio 咧，你講嗰啲嘅咩率嚇，即係包括資本金或者係嗰個流動性啊、槓桿比率咧，你擺咗啲 buffer 落去嘅，即係佢唔係 hit 到已經係唔符合嗰個監管標準，因為譬如你有個 capital 又講110%。係佢最低嗰個資本嘅然後咧 liquidity 頭先我哋講下，比如係100蚊，咁佢咧就即係如果跌到咧係120嘅話咧，低過120啦，咁佢就要通知你啦咁樣。咁所以我自己覺得即係會 guided by 即係主席你睇下，即係會唔會係 ought to know 係即係點樣平衡對嗰個公眾擺咗啲物喺佢嗰度，因為佢 registrar 其實將來嗰個整體個責任都比較重大嘅，尤其是有人 certificated 即係無紙化之後，咁點樣去平衡啊？因為你而家淨係 actual knowledge 啦，可能亦都冇一個參考嘅，係咪？即係你呢一套規則有冇一個 model 案？有嘅係嘛？即係如果你有嘅話咧，我舉一舉你嗰個 model 係咁樣去管理嗰啲受規管嘅機構咧，夠㗎啦，因為你係用我哋就依賴個 buffer。因為有個 buffer 喺度，所以咧佢實際上知道都足夠。我想聽一聽，即係考慮咗啲咩？我哋點樣平衡？
同啱條問題有少少相近，不過睇下仲有冇啲咩補充，因為即係的確可能比較難證實，但係睇下陣間
同埋
會啲咩。
F 嗰度都係嘅，即係 F 咧就特別，我想問 F 嘅，因為你要連續3日啊嘛。咁點解要揀連續3日唔能夠去支付佢嗰啲嘅欠款咧？先至會係需要通知咧。嗰3日係咪可以有啲即係比較有啲 artificial 咧？我2日又還咗佢咁樣，咁係咪點解要連續3天係點樣嚟嘅？或者你引翻嗰個 source 咧？唔該。
係，證監會。
Thank you, Mr. Chairman, for that question. So these levels are set by reference to equal requirements we have in respect of brokers. So we have drawn reference to the broker regulation in setting these out. We can dig out the relevant provisioning.
我諗即係亦都係個風險啦，即係如果對嗰啲 broker 嘅暴露咧，同對嗰個 registrar 嚇，即係我哋要衡量一下係唔係即係可比啦。如果認為係可比嘅，我接受呢個即係安排啦嚇。如果認為係對 registrar 個風險會大啲嘅時候，我覺得即係值得商榷嚇。唔該主席。
好，繼續證監會嚇。
So
睇你第10有冇補充，冇嘅話可以再繼續下一部分。
So we move on to Rule 10, Clause 10. So these are requirements regarding notification under Rule 10. So this deals with requiring. So when, sorry, I beg your pardon, I got a bit lost. Right. So when an approved securities registrar is required to notify the Commission of a matter under Rule 9, full details of the matter and the reasons for it must also be included. And so subclause 2 expands on the matters that need to be set out in the notification to the SFC. So it includes matters such as what they are doing to redress the issue, and what they are doing to prevent, say, for example, the capital from falling below the financial resources requirements. And they must also provide the Commission with such other additional information as we may reasonably require. So Rule 10 basically is supplemental to Rule 9, the Rule 9 notification requirement.
係何景康副主席。
多謝主席。 I guess my question is that under Rule 9 and 10, so any securities company are required to, when it becomes aware that its financial situation falls below a certain liquidity standard or, gearing ratio showing up above 50%, so they have the obligation to notify by written notice to the SFC. So are there any provisions as a penalty clause if they don't? And if the SFC were made aware of those situations from other means or sources, such as investors or anything like that, or losses has already been incurred because of such financial situation, are there any penalties clauses that will be imposed upon these securities companies?
Yeah, thank you for that question. So the way this regime works is pretty much similar to the way our broker regime works as well. So there is a disciplinary regime under the SFO, under Part 9 of the SFO. And so if there's any breach of any of the requirements here, it would be open to the SFC to take regulatory action against the ASR.
Okay.
And the regulatory action includes, reprimands, suspension of their approval, revocation of their approval, the usual stuff.
Okay.
Moving then to Part 4 and the keeping of records. So Clause 11 requires or sets out the obligations relating to record keeping vis-a-vis the ASR. So key items include that they must have sufficient records. Their records must be sufficient to explain and reflect their financial position, demonstrate compliance with the ASR rules, account for all property and information received, enable all movements of property to be traced, enable all activities, transactions, and communication instructions to be traced, and account for all entries in the register of holders. Subclause 2 notes that the records must be retained for a period of not less than 7 years. Subclause 3 notes that the ASR must adopt all reasonably necessary procedures to guard against falsification and to facilitate discovery. Turning then to Clause 12. Clause 12.
或者我哋而家差唔多開到一半嘅時間，我哋可以休息5分鐘，咁大家即係可以係啦，休息一下5分鐘，翻嚟，唔該。